Welcome back to the Daily Drum on WHUR and Sirius XM Channel 141. This is the Insight segment. I'm Harold Fisher. It's an Ask the Lawyer segment with personal injury attorney Andy Bederman. He's celebrating a major milestone marking 40 years in the legal profession. And tonight, we will take a look at his pioneering career as well as the evolution of the legal profession, as well as the new challenges facing those who are seeking justice after personal injury. Andy, thank you so much for joining us, and congratulations.
Thank you very much. And it's my pleasure to be here with you again.
Sure thing. I guess the first thing when you talk about 40 years in any career is a long time. That suggests tenacity, endurance, and certainly for some people a level of success. Has it hit you?
Yeah. It has actually, and I've been celebrating, but thinking about this day, because today is the actual anniversary. I've been thinking about it for a while because I've done a fair amount of radio and TV in the last several days about the anniversary. And I think that, I think about it, and I think about my career, and I think about the course of my career. And when I started it in 1978, when I came back here, it's just it's a long way from there to where I am today. A lot of water has flowed under the bridge in the interim. In 1985, my late partner Roger Greenberg and I got together. We had both been practicing personal injury law in the DMV for me 7 years, and for him it was 17 years because he was 10 years older than me. We were both working in jobs where we were very unhappy, and we wanted to do something on our own. So we had met in the courtroom actually and became friends and started talking, and ultimately decided to leave our then jobs and to create Greenberg and Bederman, which we did on the 15th of October, 1985. We got together for two reasons. One, we're plaintiffs lawyers, we're victims lawyers. We like to help people. That's what we do. I think that's why most plaintiffs lawyers are attracted to that work rather than working for the other side, where the job really is to not really help people, but to make sure they get as little money as possible if you work for the insurance companies. So we wanted to continue doing that. And also, lawyer advertising had just been legalized several years before. And we saw that as an opportunity, a very new and unique opportunity to use advertising to reach a broader public and to build a practice more quickly than you could doing it the old-fashioned way, which was word of mouth and joining organizations and speaking and all that. So we borrowed some money, took a risk, borrowed a fair amount of money, made some ads, and started advertising. And our practice grew very quickly. People responded when they knew that you didn't have to have, a bag full of money to hire a lawyer, that you could hire a lawyer who didn't get paid unless he or she won the case. So we started doing it, and it was almost instantaneously successful. We would run ads, and the phones had lights on them then, and lights would light up one after another. Boom, 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 boom. That doesn't really happen anymore because I'm practicing in a different world. But we did it, and it worked, and we kept on doing it and kept on reinvesting and used that to grow the firm. So in the last 40 years, we've probably represented 40,000 people, if not more, in the DMV. The vast majority of them, and I'm in a service business, you can't keep everyone happy, but we've been pretty successful keeping virtually all of our clients happy by getting them good results.
Let me ask you something. You said, at that point when your firm started growing, and I think this is important for people who may have either a misunderstanding or no understanding at all about how law firms work. You said that doesn't happen anymore. Why doesn't it happen?
I mean, in terms of the lights on the phone lighting up.
Yes.
I mean, why is there no more direct response? There's no more I can speak about my experience. As someone who's advertised for 40 years and has a pretty well-known brand here in the DMV. Everyone knows our names, and since I've been the spokesperson for the firm since my partner died in 2013, I mean, I'm recognizable all over the place. Most of the time, it's 99% of the time it's a blast. Sometimes it's it's not, but by and large, it's great. But it's different because people saw that what we were doing, which at that point in time was really not well accepted. We took a lot of grief from our fellow attorneys who thought advertising was unprofessional, it damaged the profession, da 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 da. They all do it now, but we kept on doing it, in the face of opposition from our colleagues. But it's different now because everybody does it now, because we demonstrated pretty early on that it was successful, that it worked, that you could use advertising to build a practice quickly, because people didn't know that you didn't have to have $1,000 to pay a retainer simply to talk to a lawyer. People didn't know that lawyers worked on a contingent fee, which means we don't get paid unless we win for you. It's that simple. People didn't know that. Now they know that. Other attorneys, what do they say? Imitation is the greatest form of flattery, right? We were on TV. No one else was on TV here. Then other people started to appear on TV. We got on radio. No one was on radio. Everybody else is on radio now. The internet appeared, right? We got on the internet in a big way. Everybody else is on the internet now. So there's just a lot more competition. So really, to answer your question, there are two reasons why it's not like it was when the ad would run and the phones would light up. Number one, everybody knows us. So I really can't tell you where cases come from because our brand is too well known. But people know us. And secondly, there's a lot more competition. That's all. Those are the two principal reasons.
So before radio and television advertising, how did you find business with, personal injury? I mean, I know you've heard, that term ambulance chaser,
right,
and the like, but outside of that, derogatory term, but I mean, if you're a new lawyer, you pass the bar, you can practice in Maryland, DC, Virginia, etc. I mean, how did you get business? I mean, I'm fascinated by that.
I think in the old days, when I say the old days, the years before I became a licensed attorney in 1978, I think in the old days, you would get clients by word of mouth.
Mm-hmm.
You get clients by joining all sorts of civic organizations. You would get clients by speaking, perhaps to civic organizations, and really anywhere you could. And as you became more well known to the public, then people would either contact you or they would send others your way. And that's sort of how it was done. And it was, and for the people that did that, it was very successful. You mentioned the word ambulance chaser. I've never really cared for that word. I think it
right. It is not a positive term.
It was just not at all. And there were attorneys who would do just that. Not literally chase an ambulance, but they would be, go to the hospital emergency rooms and outrightly solicit people, right, which is unethical and illegal. But a lot of people did that, and that's how they got business. You may not know this, but in the district about 10 years ago, 15 years ago, a law was passed that made that illegal. Because not only were there lawyers going to the hospital, but there were also what are called runners. So lawyers would pay non-lawyer third parties a little money, to send them cases. And what the runners would do is and this is also illegal in DC. The runners would, go to the Metropolitan Police and get a copy of the police report illegally, right? And then reach out to the victim named on the police report, claiming they were an investigator, and then connect them with a lawyer who had paid the runner to get the case. All of that was outlawed in the district about 10 or 15 years ago. And the practice really has stopped. But that was also another way that some people might have built their practice, but not the proper way. Advertising turned all that on its head because it gave you a way to reach massive numbers of people, right? Either on their telephone, or on their TV, or listening to the radio, surfing the web, so on and so on. Reach them and let them know that you're available to help them. And that's worked for people. I mean, nowadays, new lawyers entering the market who want to build a practice through marketing really don't go on TV. Linear TV, traditional TV is pretty much a thing of the past. Viewership is down, audiences are smaller. So people use the internet now to reach out to the public. It works. It's successful. It really is successful for other people. The advantage I have is that I've been around for a long time. People know us, and we have a large following, a huge referral base, and a large following, and a tremendous number of really good Google reviews from former clients.
Yeah. So speaking of the internet, uh, I'm sure that you are, well aware of all of the information to consumers of legal services that is out there. Certainly, there is AI, Chat GPT, OpenAI, etc. Um, and obviously, not all of the information that is available online is always helpful or accurate.
I agree.
But what is your opinion? I mean, some people think that they can just be their own lawyers,
Right.
and perhaps for the speeding ticket when you're going over the speed limit, you know 12 miles an hour, yeah, you can go to court on your own. You don't need that. But in a personal injury, for example, um, what's your take on the availability of legal information online, even if they just need a primer before coming to see you?
I can't speak about other information. I can speak about my information that's online, which is 100% accurate. But I'm sure that there are bad apples in every barrel. There's fraud in every walk of life, unfortunately. And I'm sure there are some lawyers who will, who will engage in puffery online, like they would on the radio and on TV, right? To try to entice people to hire them, even though they may not have given them correct information, accurate information. So my advice is, if you're going to look for an attorney online and choose an attorney online, is one, visit their webpage, read what they posted there carefully, and then check them out in some independent way, like getting a reference. Check out their Google reviews, which are very, very important in this digital society that we live in. And the public can tell which reviews are real and which ones are fake, because there are fake reviews there. But I think that's a very good source of information about the quality about the reputation of the law firm you're considering hiring, and about its reputation. Beyond that, you just have to get the lawyer-client relationship is one of trust. And if you have a good feeling about the person you're communicating with, thinking about hiring, and you feel good about it, then go with your gut and hire them. Most folks don't understand that you can discharge your lawyer typically without having to pay the lawyer any money then and there. You may have to pay money down the road, but you can discharge a lawyer for cause. And if you do so, then theoretically the lawyer's not entitled to any compensation. If it's not for cause, then you can still discharge your attorney. But like I said, they may make a claim for compensation when your case resolves.
Well, and I guess I wasn't so much even referring to information that other attorneys put out, but I'm talking about, for example, artificial intelligence, where you can go in and you can Google, what do I need to know before I pick an attorney?
Right.
Or I've had a car accident and someone was hurt. I'm not hurt. What should I do?
Right.
Next, and that's the kind of thing that I'm.
Typically, AI is the hot subject now. I'm going to a conference next week, and there are vendors, there are exhibitors, and I can guarantee you that 90% of the exhibitors will have AI after their name, because that's the hot subject in in the business world, really in the world in general, and it's it's a hot subject in the legal profession. I think AI is a good thing. The young people in my office that use it tell me they really like it, and it's generally trustworthy, but it's not entirely trustworthy at times. So, it's maybe a good place to start, but I wouldn't rely solely on whatever AI told me to make a decision, especially about hiring an attorney. These are relationships of trust. You have to feel like you have to feel good about the person you're considering hiring, and also feel that you can trust them. And if you don't, then you shouldn't hire them. And if you did hire them, you ought to get rid of them. It's just that simple. And I tell clients that, if at any time you don't trust us, then I would urge you to discharge us, really, because we're not going to have a good relationship long term down the road.
I've got so many more questions
Okay, go ahead, move on.
for
Well,
you, but I do need to take a really quick break. And I want to remind our listeners that you can hear this and every edition of the Daily Drum Insight segment via podcast on WHUR.com. The Original Quiet Storm with Raheem Devon is coming up next on WHUR-FM. This conversation continues on Sirius XM channel 141 and 96.3 HD2 in just a few seconds. Welcome back to the Daily Drum on Sirius XM channel 141. I'm Harold Fisher. We continue our Ask the Lawyer conversation with Andy Bederman, managing partner at injury law firm Greenberg and Bederman. Andy is celebrating 40 years in the legal profession, and certainly we extend our congratulations for that. And some of these questions are they I mean, how often do we, that's why we do this segment, because how often do we have a chance to ask? How many associates do you have at your firm?
There are now 15 lawyers, including me.
How do you, look, as a big fan of the show Suits, you know, and
my
if
wife
you know,
watched it.
you
I didn't
know.
watch it, but she liked it. She loved it.
Yeah, I mean, it's, you know, it's stylish, and I'm sure there's a lot of drama in it, you know.
Right.
But how do you determine, how do you go about hiring a new associate? I mean, what, you know, obviously they got to go to law school. That's a no-brainer. I get it. I'm assuming they have to pass the bar. But what are the kind of intangible things that you look for a young attorney? I mean, do you hire them straight off the bar out of law school, or what?
Generally speaking, yes, we hire kids right out of law school. I've got a couple kids here now who are waiting on their Maryland bar results this Friday, so they're a little nervous. But yeah, I mean, I like to hire. Generally speaking, I like to hire young people so we can train them and mold them to be lawyers that we like to have in our office. And if someone is, you know, the older someone gets, I tell you and myself, the more difficult it becomes to change your ways. So that's why we like to work with young people like pieces of clay that we can mold. And I look for people that are like me, or should I say that were like me at that age. And I guess I'm still the same way. I like people that want to work, come to work on time, work hard when they're here, and are, you know, are relatively quick studies. I often tell people I don't need to pay people to make mistakes. I can do that myself. But if you do make a mistake, as we all do, and it's a good learning experience, let us know. Because if you don't let us know that you've made a mistake, then we can't help you learn so that you don't make that mistake again. You know, if you make a mistake more than once, if you make it over and over again, then maybe there's a problem. But that's pretty, you know, we've, in the past that we've interviewed people, we've spoken to references, we've given them psychological tests, you know, but the bottom line is, I think, as they say, the proof is in the pudding, right? You really never know about someone until they're working for you for 3, 4, 5, 6 months, right? You'll know by then whether someone's going to work long term. The young folks I've recently hired are great, really. I found 2 wonderful young attorneys during the pandemic, and I think found another 2 recently, just got out of law school, who are waiting for their bar results. And I'm optimistic that they'll be successful. But again, it's just like any other job. You want someone who's going to, I mean, like I do. I always got to work on time, if not early. I worked hard all day. I made sure the I's were dotted, the T's were crossed, right? And I took care of my business. That's pretty much what it is.
You know, when you talk about selecting attorneys, a lot of that sounds like, you know, anybody, any manager wants somebody who comes to work on time, works hard. But are there any specific things as it relates to the law that you look for when you're hiring new attorneys?
Well, I mean, obviously, you know, you want to hire someone who's competent, who can read, who's a good reader and a good writer, a good reader, a good analyst, and a good writer, because that's all involved in the law. And also a good verbal communicator, because what we do is talk. I mean, I'm a short man. I was really short as a kid, and I talked a lot to get noticed, right? Because nobody saw me, and I still talk, but that's sort of what I do. You know, as I explained to one of the TV stations this morning, I was horrible in math and science. I was good in reading, writing, critical analysis, and most importantly, talking. And that sort of led me, and that and Perry Mason led me to the law.
Mm-hmm.
Here I am 47 years down the road. But obviously you want someone who's got those basic legal skills: reading, analysis, writing, verbal expression. And if you'll know during the interview process whether someone has most of those intangibles. Whether they really fit into your office is a different story, and you won't know until they work for you.
So you mentioned Perry Mason, which brings me to my next question: whether it's Perry Mason, Law and Order, Suits, what have you, any legal drama, assuming that an attorney, new or seasoned, has a good foundation, how important is having a dynamic personality in court? I mean, we see it on TV, but some people will never meet Andy Bederman,
right?
And being a personal injury lawyer, you certainly hope that you are never in a position like that. But if you are, does having a dynamic personality as opposed to being, kind of vanilla or just, blah, does it matter in court?
Well, of my 15 lawyers, only about a third are litigators. So you have to understand that not every lawyer in a law office is a litigator who goes to court.
Mm-hmm.
People do other things. I have intake attorneys who help all the clients that call us about representation, right? They screen the cases, they decide whether we're going to take them or not, and if so, help the people sign the appropriate documents to hire us. We have pre-litigation attorneys who handle cases prior to a lawsuit being filed. You have to understand, filing a lawsuit is the last step in the process, right? Someone has an accident, simple car accident, they come to you, they're injured, they get medical care, they get well, you collect all the documentation, you analyze it, then you submit it to the insurance company and try to settle the case voluntarily without filing suit. About 2/3 of the cases settle that way, but the other third don't. And so the pre-lit attorneys handle the cases up to the point that, at least in my office, to the point that they get submitted for settlement. Then I have a settlement team, which is composed of other attorneys who actually negotiate with the insurance companies to try to settle the cases. And if they can, great. And if they can't, then they go to litigation. Then they're handled by a different segment of my staff, my attorney staff. But I think if you're going to be a successful litigator, it's good to be a good communicator.
Okay.
It's good to be a good communicator, and it's good to be sincere by nature and to be able to convey that sincerity to the members of the jury. Those are the people you're trying to sell. They're the people you're trying to persuade about the virtues and merits of your client's case. But I don't think you have to be, you don't have to be an actor or a cheerleader or anything like that. You don't have to be extraordinarily enthusiastic. I just think you should be, if you come off as sincere and a good communicator, right, and not boring, then you'll be successful. Bearing in mind, of course, that it all really boils down ultimately to the facts of your case, and how the jury responds to your client, whether they like the client or not.
You mentioned with young attorneys making mistakes. If you're comfortable talking about it, what do you think is the biggest mistake that you've made that was pivotal in your success, that when it was all said and done, you looked in the mirror and said, Andy, you're not doing that again?
To answer your question, there are no examples that come to mind with respect to any case that I handled. I mean, there have been business marketing decisions that I've made that I wish I hadn't made in the course of my career, but that's just sort of redirected my marketing efforts in a different direction. That's all. But nothing real. I mean, it's really nothing. To answer your question in a general sense, the biggest mistake that attorneys make, in my opinion, from my perspective, almost 50 years down the road, is not communicating with their clients on a regular basis. I have a rule here. If you call us or you reach out to us digitally these days by email or text, you got to respond immediately, but no later than 24 hours.
Mm-hmm.
What I don't want to hear, and what I don't see anymore, and really haven't for a long time, is an email, a call, an email, or a text from a client saying, you haven't responded to me. That makes my blood boil. And this is not rocket science stuff. This is very simple. In this sense, the law is no different than any other business. right? You spend, in our case, we spend advertising dollars to attract clients. They hire us. It's our job to do the job, do the work, and get it done properly and keep the client informed and happy. So that's the biggest mistake that attorneys make, failure to communicate. And that's the biggest mistake that leads to grievances against attorneys. Clients file grievances with, and for instance, like in DC, it's the Office of Professional Responsibility. In Maryland, it's, Bar Council. So that's the biggest mistake lawyers make, in my opinion.
Yeah, I would agree as a layperson, because there have been times over the years where I've spoken to friends who are dealing with lawyers, and they may have a case. It may be a personal injury case. And I may say, well, how's it going? Well, I've been trying to reach my attorney and I haven't been able to talk to him or her. And that kind of thing does give you pause. And one of the other things, and I'm sure you can probably relate to this too, and this, or at least understand that because consumers are better educated now than I would imagine they were 20, 30, 40 years ago, that sometimes they call their attorney and ask a question, don't get a response, and they end up finding out the answer on their own. Mm-hmm. That is a black mark, no question. I would imagine.
Well, I would agree. I mean, again, it's all about communication. We work for the clients. The clients reach out to us. They deserve a response immediately. When I woke up this morning, one of my clients emailed me at 4 a.m. I'm an early riser. I responded to her at 7. I mean, these cell phones have changed the business world, as you know. So I could be anywhere in the world and I could be connected to my office and to my case management software and to my email and so on, and my text, and I can respond to people if I need to. But again, that's the biggest mistake lawyers have made throughout my career, not responding to people at all, or timely for that matter.
You mentioned the law in the District of Columbia that changed how attorneys were able to get personal injury clients. But outside of that, are there any other watershed laws in the DMV that affected not just your practice, but all lawyers that you thought were particularly pivotal?
Well, that covers a lot of territory, but and there was a movement in the United States the last 20, 30 years to place caps on or limits on damages that you could recover.
Yes, yes.
The district has never had a cap, which is great. Maryland has had a cap since the mid 80s. The Trial Lawyers Association of Maryland has been successful the last 10 or 15 years in getting it increased. But in Maryland, there's a cap that applies to all injury cases. And it's a cap on what's called non-economic damages. In injury cases, you have economic damages, medical expenses, lost wages, anything you can put a number on immediately. And then we have non-economic damages, which are your injury, your recovery from your injury, your pain and suffering, and then permanency. It could be, permanent limitation, or it could be scarring. And in Maryland, there's now a cap. It's about $800,000 on non-economic damages. So to give you a horrible example, I had a case that just resolved with my partner last year involving a gas explosion that occurred in an apartment complex in Silver Spring, where a maintenance man was trying to clear a drain and he couldn't get it cleared, and he cut a pipe that he thought was the waste pipe, and it was a gas pipe.
Gas pipe. Yes, I am familiar with that. It was big news.
Yes. It was big news. And it was, if you saw the video of the explosion, it was like something out of Hollywood. Mm-hmm. They settled for very significant money because my client was horribly, horribly burned. I've had a number of burn cases in my career involving adults and kids, and I've never seen anything quite like this. And unfortunately, since the incident occurred about a mile from the district line in Silver Spring, right, her non-economic damages were capped at $800,000. Does it happen in the district? There would have been no cap, and a jury would have awarded her generous compensation, far more than she got because the accident happened in Maryland. So that's one real big problem in the law. Another thing that came up recently is, and this is quite interesting, in the district, Maryland, DC, and Virginia are 3 of 5 states in the country that still follow a theory of law called contributory negligence. Let's give you a simple auto accident example. Let's say you have a car accident, right? And you can prove that the other driver was responsible, right?
Mm-hmm.
Burden then shifts to the other driver to prove, if he or she can, that you contributed to the accident in some way. And if they can prove that you contributed even a percentage of a percent, then theoretically you're entitled to no compensation, which is terrible, right? The rest of the country follows a theory of law called comparative negligence, which generally provides that if you can prove that the other driver was responsible, and he can then turn around and prove that you were contributory in some way, you don't lose everything, but your monetary recovery, the damages you get, will be reduced by the percentage extent to which you contributed to the accident. So let's say a jury's going to award you $10, and they find that you were 20% contributory. You're going to get $10 less 20%. You're going to get $8 instead of 10, right? And the district, and generally speaking, that works unless you're 50% or more responsible. If you're 51% responsible, you get nothing, right? So in 2020, the district changed its laws as they apply to, I'm reading from the law here, bicyclists, motorcyclists, scooters, non-motorized scooters, and skateboards. So and pedestrians. So if you're on one of these, if you're walking or you're on one of these devices and you have an accident, then the law of comparative negligence applies to you. As long as you're not 51% or more responsible, then you'll recover. And if the judge finds that you contributed to some percentage extent, then your recovery will be reduced by that amount. So it's a great legal development, because otherwise these people would get nothing. They'd be disqualified from compensation, which is not good.
I want to ask more about the personal injury part. If someone has any kind of accident or incident, it could be a car accident, slip and fall in a department store, it could be medical malpractice. What should they do immediately after this incident occurs before they call you?
Okay, so it's a good question, and there are really two types of cases you mentioned. So the auto accident, right? What you shouldn't, if you have an auto accident, you stop, get out of the car, you exchange information with the other driver. With these beautiful phones that we have now, you can start taking pictures. You want to photograph the other vehicle and its damage. You want to photograph the license plate. You want to photograph the registration, the insurance card. You want to photograph that. And you don't want to leave the scene. You want to call the police. If there's an injury, the police will come. They may come anyway, but not write a report. But generally speaking, you want to call the police. And if someone's injured, you definitely want to call an ambulance. But don't leave the scene until the police have arrived. If they do, you've had a chance to speak to them. And don't leave the scene until you've collected all this information. Very, very important. Very important. With respect to a slip and fall in a store, right? If you do happen to slip and fall in a store, you don't want to leave the scene until you've reported that incident to the management, right? Because once you do that, that's going to generate a report, which will be the only official record, really, unless an ambulance comes and picks you up at the scene there, but the only official record of what happened. And of course, in both types of cases, if you know of any witnesses, if any witnesses identify themselves, you can identify them. They're at the motor vehicle accident scene or, at the store where you fell, right? Then you want to get their contact information because it can be very, very important. Very important. You mentioned slips and falls in stores. And what I just said about contributory negligence really applies to them. We're 3 of 5 states in the country, go figure, that still follow this theory of law. And in slip and falls in stores, what we call contributory negligence is always going to be an issue. We're always going to say, well, they weren't walking where they were walking. If they were paying attention to where they were walking, they wouldn't have seen it, right? What's interesting about these slips and falls in stores is that just because you fall doesn't mean the store owner or manager is responsible. You still have to prove negligence. In the premises context, that means you have to show that they knew or should have known that there was a problem and failed to do something about it. So the great law school example is slipping on a grape at the grocery store.
Right.
You slip on a grape and the grape is green, looks like it's fresh. It's unlikely it's been on the floor for very long. It's probably not a good case. But if the grape is, is somehow discolored, which means that it's been rotting, that's some evidence that it's been on the floor for a longer period of time, and you may have a case there.
Wow.
Something like slipping on water in a store. Just because there's water on the floor doesn't mean that they're responsible. You got to be able to show that they knew or should have known that the water was there.
Mm-hmm.
You might have a witness that say it was there for half an hour, right? Or there may be maintenance records or the absence of maintenance records that showed, that they didn't do periodic inspections of the floor. So they're just very tough cases in the DMV, really tough cases.
When you talk about, again, personal injury or vehicle accidents, for example, how do you prepare clients for how long settlement may take, particularly if you have one that may involve, this happened to me when I was in my 20s, where I was a police officer, hit my car. I'd only had my car for 29 days. No sirens, no lights. He ran a red light, hit my car. I was not injured, but my car was totaled. It took a couple of years to settle that. And suffice it to say, I was particularly annoyed. But the other side of that is, if you have an accident, same kind of accident, with someone who is insured, is there a difference between dealing with municipalities versus people who are privately insured?
Absolutely. It's a very good question too. Most commercial insurers, I'd say most. If you never thought that auto insurance wasn't profitable, look at the amount of TV advertising that the auto insurers pay for. It's crazy. It's insane. So it's a very profitable line of business for them. But be that as it may, the big insurance carriers, for the most part, have very well-oiled claims handling machines. In the typical case, if there are no issues, you call the insurance company for the person that hit you, and they're going to look at your car. They're going to estimate the damage to your car, tell you whether it's repairable or a total loss, and they're going to put you on a rental for a period of time at their expense, generally speaking. Governmental entities are not like commercial insurers, and in fact, most of them are self-insured. I say governmental entities, I mean the federal government, state governments, local governments. First and foremost, there are laws that set forth how you need to put them in notice on notice of your claim in writing within a specific period of time, and if you don't, you lose your rights. Number two, they're self-insured. Many of them handle claims on their own, or they'll hire what's called a TPA, or third-party administrator, to basically act as their claim service, even though ultimately they're paying because they're self-insured. And it just doesn't move as quickly or as efficiently as it does with a commercial insurer, to the public's detriment. I mean, I've had clients rear-ended by police cars, and 3 months later, their property damage hasn't been addressed. We'll tell them, go rent a car at your own expense. Well, most folks can't afford that.
Right.
And your bottom line is it's difficult. It's not a good situation. So, and on top of that, maybe it's because it's public money, the governmental entities tend to be a little cheaper, a little tighter with their dollars than commercial insurers are. None of them are generous. There's no question about that, but that's been my experience. Yeah,
and I said 2 years. I'm literally counting. It took 3 years to settle that.
Right.
Yeah.
Well, again, every case is different. So I don't know the specifics, but
right.
Typical minor injury case in my office. Typical minor injury case. I tell people this, and that's to answer your question about the length of time. It's all about communication. You got to let people know. Let them know what the process is, how long this will likely take, and keep on reminding them of that. I was telling you something. I lost my train of thought there. What was I saying?
And that's why we were just talking about, the difference between private versus, public entities. But, I have a few minutes left, and I did want to ask you this because, as I said in the beginning, after some 40 years for this firm, but as you said, almost 50 years for yourself, you have achieved a modicum of success. What do you believe that your personal responsibility is to the world outside of the law firm? I mean, do you have a charity? Do you have a cause that you want or have had the law firm support?
There are actually several causes. That's a good question because the DMV has been good to us. It really has been. I was born here, raised here, educated here. I spent my formative years as a child here and as a young man. Left to go to college and law school, but then came home and was re-embraced by the DMV in 1978 when I came back with my wife. And I've been blessed to have a great career, to start this law firm, to grow it, to help tens of thousands of people navigate the legal system, which can be very, very difficult and slow, as you know. And about 15 years ago, my partner was alive. We decided, look, it's time to start giving back to the community. And since then, we've been giving. There's a couple things we do. We give backpacks to school children in August, loaded with school supplies. We give turkey dinners to needy families at Thanksgiving. We've given money to the Prince George's County Police Boys and Girls Program.
Okay.
We recently sponsored several ethnic festivals, Ethiopian festivals, actually. There's a big one in Silver Spring we sponsored. There's a great event. There was one this past weekend in Alexandria that we sponsored. And these are great events where we can use the our good fortune, if you will, to get back to the community that's been so good to us. And we plan to keep on doing so. We really do. And that to me is the icing on my cake, if you will. Yeah. I don't go anywhere. Even despite my age, I'm still working, and I'll be here as long as I can function.
Well, that was my next question. You said you're 72.
Right.
Did you? What do you want your legacy to be? And at what point do you feel that it'll be time for you to, hang up the books and?
Yeah. My legacy is going to be what my law firm has done for the DMV. That's the principal legacy. The second legacy is going to be what my practice has enabled me to do for my family, my wife, my kids, my grandkids, siblings, nieces and nephews, and so on. But I'm notwithstanding my age, I'm in the best shape I've ever been in. I feel good. Fortunately, since I have so many younger attorneys working for me, I don't have to work as hard as I did 40 years ago, but I still work. And I'm very focused on marketing, on making sure that, that this legacy that this brand, if you will, and legacy that we've created continues to be well known and continues to help people. So that's kind of what I focus on these days, and I continue to do that. I'll work until my wife demands that I stop working. I'm not sure she's ready for that. Her dad was a doctor and worked till he was almost 80. But I'll work as long as I can continue to be helpful and effective. And hopefully that'll be. I'll reevaluate things in a couple of years, but I plan to keep on going as long as I can.
Well, I think I'll end the conversation here. But good luck to you. Good health to you. Keep doing what you've been doing, not only for the community, but I think it's also important that in these conversations that we have the ability to educate people, because there's so much that people do not know.
I agree entirely.
And I got my law degree from 20 years of Law and Order, so you can't hire me.
The only thing I want to say in parting to your audience is that, one, I love you all.
Thank you.
But two, if you have an accident, if you're injured and you're thinking about making a claim, talk to an attorney. You don't have to hire the attorney, but talk to them, because the insurance companies are armed with adjusters who are trained like lawyers. And their job is not to be your friend and not to help you, but to settle your case, get your signature on a release for as little money as possible, as quickly as possible. So don't succumb to that temptation. At least talk to an attorney. And thereafter, if you want to sign off, but don't without speaking to a lawyer first.
Good advice. Thank you so very, very much, Andy
Good to see you
Bederman with Greenberg and Bederman. I appreciate your time.
Likewise. You take care.
That is the Daily Drum for this Wednesday, October 15th. I'm Harold Fisher. Good night.